Well, good afternoon, everyone. My name is Tim Blotz from Fox 9 News in Minneapolis. Welcome to our streaming coverage of Day 4 of the federal civil rights trial for the 3 former Minneapolis police officers who assisted in the arrest of George Floyd. Now, the 3 officers are J. Alexander King, Thomas Lane, and Tu Tao. All 3 are accused of depriving George Floyd of his civil rights during that arrest on May 25th of 2020 when he was placed under arrest for trying to pass a counterfeit $20 bill at Cub Foods, which is at 38th in Chicago here in Minneapolis. Derek Chauvin, the 4th officer, of course, was on the scene that day, has already pleaded guilty in this federal civil rights trial. He is also serving a 22-year prison sentence after a Hennepin County jury found him guilty of killing George Floyd. Now, our Rob Olson has been in federal court all week long in St. Paul. He joins us now live. We are now right in the middle of the lunch break. Rob has been in court all morning long, where one of the main testimonies today has been coming from Minneapolis Police Inspector Katie Blackwell. Bring us up to speed in her background, Rob.
Well, she is currently the inspector for the 5th precinct for Minneapolis Police, but on May 25th of 2020, when George Floyd was murdered, she was the commander of the training division. So much of this, and again, she's been on the stand all morning long. It started about a little after 9:30, laying a lot of the foundation. Of course, in every trial, when you bring every witness on, a big part of this for the jury is that you have to go through their background and their resume and the timeline of what they've done and why, and so there's a lot of that stuff that's really sort of biographical for the jury for each of the witnesses, and especially for this one, because she is the commander of the training division. What she's testifying is about the training that officers receive, not only through the academy, but the field training, and then the policies and procedures that they're told about. Because again, this is a trial that is examining, that has charged these 3 former officers with failing to intervene in what Derek Chauvin was doing and failing to provide medical aid to George Floyd. Those are the constitutional rights violations. So that's where all of this becomes important, is talking about policies and procedures about not only the use of force, but also the duty to intervene, and the policies regarding medical aid to people who are in your custody. And you know, in the opening statements, the prosecution talked about in your custody is in your care, and Katie Blackwell said, yeah, that is part of their policy. That is part of their mantra. That is part of what they believe, is that in your custody is in your care. So that's a big part of what they also teach their officers in regards to people that they are detaining or have detained or attempting to.
Rob, with this particular case, what did she testify to today in terms of the obligation of these 3 officers to have intervened after what they saw or were a part of there?
Yeah, and that's what was gotten into later in the morning today, the policies and procedures of the Minneapolis Police Department. There was a code of conduct that they talked about, but what was really, again, that she zeroed in on was first the use of force policy for the Minneapolis Police Department, that if they're using an unreasonable well, this is also the duty to intervene and the duty of others to report about the use of force that they see. She said if they're using an unreasonable amount of force, they should be reporting that. We have a pretty lengthy use of force policy. It's a big one we don't want our officers to violate, and we teach them to use the lowest level of force possible when they detain somebody. And then about the duty to intervene policy. Now, that is a policy that became, official policy in 2016 in the training and procedures manual. But she said that duty to intervene has always been part of the policy, maybe unwritten policy for police departments as far back as she can remember, that she's been a police officer. And what she said, she was asked what it means, the in custody in your care, that you must do everything possible to protect this person. As far as the duty to intervene, again, talking about if you see something, it is in fact your duty. They did go over the official policy in there as well, and I'm trying to find in my notes. I got about 8 pages here, Tim.
Oh, no worries, no worries.
But it is sworn employees have an obligation to protect the public, and when employees present at any scene where physical force is being applied to either stop or attempt to stop another sworn employee when that force is being inappropriately applied or no longer required.
Okay,
so that's kind of the key part here.
So that's what the policy says, according to Inspector Blackwell. Was she asked by the prosecution whether she viewed that these 3 officers at that moment had the duty to intervene? Should have they intervened?
It has not gotten to that point yet, and I think that is something certainly you will find once we get to cross-examination from the 3 defense attorneys in the courtroom. The judge, though, is being very careful, and about some of the questioning here. If it gets too speculative, or he sustained objections about the prosecution questioning being too leading. That's where you're trying to go in a certain direction. He's very careful not to go there. He's also been warning them about repetitive questioning because he wants to keep this thing moving along. But so it's not gotten to that point where she's asked about her viewpoint on what was occurring. This is just all about what is in the training and what is in the manual, what is something that these officers should know.
And a key aspect of that, even in the state trial against Derek Chauvin, has been the use of neck restraints. What did she testify today as to the use of force with regards to the neck?
What their policy is that they have, and let me get down to the section of my notes here, that there are neck restraints and there are chokeholds, and there is a conscious neck restraint and an unconscious neck restraint. And so what she testified to is that their training is, and their policy, which they showed, is that if you use a neck restraint, it's typically with the arm or the elbow around somebody's neck, pressure applied on both sides of the neck, and that is to cut off circulation, to render somebody, either a conscious neck restraint is to slow them down, an unconscious neck restraint is to literally render them unconscious if there's an issue, but then immediately, make sure that they're okay. You don't continue to hold the restraint at that point, but it's enough to get them handcuffed or put into some other restraint device if necessary. A chokehold is considered a deadly use of force, and that is where somebody's airway is literally cut off. They do train the conscious and unconscious neck restraints, cutting off circulation, and they go through it, and they usually do it on an instructor to show how quickly it happens. 6 to 15 seconds, she said, is what it takes. So that is trained. Whether or not a leg is used, she was asked about that because Derek Chauvin had a knee on the neck. She said they do not train to use a leg, just the arms. Rob,
you've been the pool reporter inside of the courtroom itself today. Up until today, you've been watching from the media room on closed circuit TV. And I'm curious to know your observations, because so many times when you're in the courtroom, there are so many contextual details that you can pick up as a reporter and an observer that none of us can see on closed circuit TV. And I'd love to know what you're seeing in there.
Yeah, and this one's a little different, obviously, because of COVID protocols than many of the trials that I've covered throughout my career, and there have been many of them. I mean, here you see plexiglass separating each of the jurors, and so that spreads them out, and there's many, because there's 6 alternates. So some are sitting outside the jury box to the side, closest to the back wall. There's 3 that are in kind of a cordoned off area in the front that's normally on the floor in front of the jury box. And what you kind of notice too is, you're looking for reactions and just kind of seeing what's going on. Today has been so dry because it's all policy and procedure and training that you haven't seen really much responses from anybody in there in terms of anything emotional. Because again, there's been no video played today to this point so far. None of those pieces of body camera or other security cameras shown of the scene there, of the incident. So it's been pretty quiet in there. You have a very crowded defense table. I'm sitting right behind that. And so, you know, that's what you notice there, the three defendants and their attorneys. There are four defense attorneys among the three defendants up there. And, you know, and then the jury box. And, you know, everybody's playing, you can see, everybody's very much paying close attention to this, but, you know, reactions are, you know, nobody's really making any visible reaction to anything because, again, it's very much like a more of a classroom setting today in terms of going through all this information versus anything that's more, you know, emotional or could elicit any kind of emotional response.
Rob, sometimes when we...
I should note, too...
I'm sorry, go ahead.
Go ahead.
Sometimes when...
Oh, I was going to note, too... Sorry, Tim. I was going to note, too, you know, follow up with what we're talking about previously, you know, when they were talking about neck restraints. They did follow that up with then the policies of aftercare, what you're supposed to do in the event that you've had to use of force or a neck restraint. And it does say in their policy, and it is in their training, that if somebody is unconscious, then they should be put either onto their side or sitting up. If they've been in a prone position, specifically like George Floyd was, and lose consciousness, the training specifically says, and the policy says, to either move them onto their side or into a sitting position if they regain consciousness.
That's an important detail out of the training manual, isn't it?
Yeah. Yeah, it is.
The question I was going to ask is that, you know, you and I have been in enough courtrooms over the years in our careers to know that sometimes the defendants are rather participatory with their attorneys in the case. I'm curious to know what you're seeing here with Mr. Lang, Mr. Tao, and Mr. Alexander as to how involved they seem to be with their attorneys as they're listening.
Yeah, I haven't seen them actually having a lot of interactions with their attorneys during the testimony, but you see them taking notes. You know, just what I've noted anecdotally is that Thomas Lane appears to be taking more notes than the other two. You know, what that means, it may mean nothing, you know, because people have different styles of taking notes. It's the same with the jurors. You know, you see some taking a lot more notes than others, but it varies. That all depends on, just like when you were a student in school, how much notes did you need to take to help your specific, you know, your memories or you know, for further down the line. But, you know, that's what I've noticed so far. Not a lot of interaction, you know, during the testimony, but certainly pretty rapt attention.
And Paul, or Rob, you've noted that Judge Magnuson is very much trying to move this trial along, trying to prevent a lot of repetitive testimony. He has always been concerned from the start of this about compressing this trial as much as he can, because he's quite frankly worried about participants getting taken out by the Omicron variant and the COVID virus.
Yeah. Very much so. I mean, he doesn't want it to go on too long. The longer you go, the higher risk you have in terms of seeing some sort of situation like that, where you might lose some jurors to infection. And so, and then part of it too is just, you know, I've seen this in other federal cases too, where they're very, very careful not to let attorneys stretch things out if completely unnecessary. So there have been objections today by defense attorneys about repetitive questioning that the judge has been sustaining, because they are variations of kind of the same questioning about the use of force policy, for example, and many of the questions really end up getting the same answers because they're different versions of them. So he doesn't want to hear that. He wants you know, if you've covered it, if it's been asked and answered, don't keep asking different versions of it. Keep moving.
Yeah, Rob, we're in the middle of the lunch break right now. They're set to come back at 2 o'clock. I'm assuming we're expecting Inspector Blackwell to retake the stand.
Yeah, actually, one interesting note there, Tim, is that as we broke, the judge told the jury, you know, at the beginning of this, I said sometimes we might have jurors or witnesses out of order and interrupt them, and today is a case. He said when we resume at 2 p.m., there'll be a different witness on the stand, somebody who can only testify today. So, I mean, their availability is limited. So they're interrupting Inspector Blackwell's testimony, putting it on pause, going with another witness. Typically, that's when you have potentially a paid witness or an expert witness who has to come into town and has a specific window. We don't know that that's the case here, but that's an example of why you have something that might be time sensitive. So there's somebody that is got an availability today. They're going to move to that witness, and then when they're done there, Inspector Blackwell then resumes. So that's a little bit of an aberration. You don't normally see that. It's not highly unusual, but it doesn't typically happen either.
All right, Rob, I know that you've got some extra responsibilities today as the pool reporter inside the courtroom, so we're going to let you get at that and grab some lunch yourself. Thanks so much.
Thank you.
Yeah, and we just want to remind those of you who are on the stream here today that we're going to have a complete wrap-up tonight on Fox 9 News at 5 o'clock. And we'll also be back here at approximately the same time tomorrow during the lunch break to give you an update on everything that's been happening in court up until then. So please join us tonight on Fox 9. On behalf of everyone here, my name is Tim Blotz. Have a warm and safe afternoon, everyone. We'll see you a little later.